Welcome back. Thank you for joining us. We'll now start with our third panel discussion on the topic of Malaysian COVID-19 pandemic response, industrial and community mediation response. In the third section, the speakers will discuss on the COVID-19 Act in Malaysia and rules by organizations, the COVID-19 Mediation Centre updates on current efforts and recent experiences, the industrial views of mediation during pandemic, the community mediation needs during pandemic, the emergence of e-mediation, and the regional institutional responses on mediation during pandemic. We are very privileged to have the esteemed panelists, including Dato Seng, who is the Honorary Secretary, the Council of the Justices of the Penang, Dr. Noorfajri Ismail, who is a Senior Lecturer of the Islamic Science University of Malaysia, Mr. Sufian Hassan, who is an Officer of the COVID-19 Mediation Centre, Mr. Dato, Secretary General of the Thai-Chinese International Arbitration and Mediation Centre, Mr. Alex Fund, President of the Hainan International Arbitration Court, HIAC, and Datuk Kuthubul Zaman Bukhari, who is the co-chairman of the Malaysian Mediation Centre, MMC. We are very proud as well to have our moderator of the session, Ms. Samrith, who is the managing partner of Samrith Sanjeev and Partners, who is also a fellow of AIADR, to moderate the session. We are now pass the floor to Ms. Samrith. Thank you.
Thank you very much for your kind introduction. Good afternoon, everyone. Thank you for joining us this afternoon for this very interesting COVID-19 Asian Mediation Forum organized by AIADR. The topic for discussion this afternoon for this session is on the Asian perspective on COVID-19 pandemic, response by the institution, industry and community mediation perspective. For this session, we are actually we're extremely fortunate to have with us an esteemed panel of speakers who will discuss how the institutions, the industries and the community mediators stepped in to raise the burden of disputants in these challenging times in cutting down costly litigation which arose due to COVID-19 pandemic lockdown and later restrictive movement control order, and now we are in a conditional movement control order. Mediation has finally taken the forefront, being the alternative dispute resolution mechanism in resolving disputes which, if parties are willing to engage, in all honesty, will definitely end up with a win-win outcome instead of a win-lose outcome. The Malaysian government, recognizing the advantages of mediation, recently passed the COVID-19 Act, which included a mediation clause encouraging disputants in engaging in mediation rather than taking up litigation before litigating. So for this third session, we will start with our speaker's presentation and we will end up taking questions from the participants. You can either direct your question to a particular speaker or ask general questions which can be taken up by any speakers. So with further ado, our first speaker is none other than Dato Kuthubul Zaman Bukhari. Dato Kuthubul has held various positions in the Malaysian Bar and the Bar Council. He was the secretary from the year 2000 to 2002, the vice president from 2002 to 2003, and the president of the Malaysian Bar and chairman of the Bar Council from 2003 to 2005. He also heads the Bar Council Arbitration and Alternative Dispute Resolution Committee. He chaired the arbitration committee that was involved in the initial drafting of the new Arbitration Act, which formed the basis of the new Arbitration Act 2005. He was the chairman of the Asian Mediation Association from 2011 to 2013 and is also the co-chairman of the Malaysian Mediation Centre. Dato Kuthubul was also appointed to sit on multiple royal commissions and was conferred the award Panglima Jasa Negara by the Yang di-Pertuan Agong, which carries the title Dato. Dato Kuthubul will take us through the Malaysian COVID Act, which was passed recently in October 2020, and the organization rules. Dato Kuthubul.
Thank you, Samrith, for the kind introduction. Can you all hear me?
Yes.
Okay. I've been allotted this topic on the COVID-19 Act in Malaysia and rules by organization. I've provided the slides to the organizers. I hope they can put up the slide. Yeah. So this is the topic that has been allotted to me, and I'm going to give you the provisions that were passed by Parliament under the COVID-19 Act. Next. Can I have the next slide, please? Yeah. No. The act that was passed by the Malaysian Parliament is called the Temporary Measures for Reducing the Impact of Coronavirus Disease 2019, that is COVID-19 2020. And the date of royal assent was given on 16 October 2020, and the date of publication is actually 23rd October 2020. The date of publication is important because I did not put this on the slide, but later I realized it's an important date because a lot of the provisions refers to the date of publication of this particular act. So the publication date is 23rd October 2020. Next, please. Basically, what the act does is that these temporary measures for reducing the impact of coronavirus disease 2019, it modifies acts and ordinances which are currently in existence, and it lists out the various acts and ordinances which will be affected by the passing of these temporary measures under the COVID-19 Act. And those are the acts which are affected by this passing of this new Act of Parliament. Next, please. Yeah. From A to P, these are the acts and ordinances which are modified pursuant to this act. So if anything that comes within this provision, then you need to look at the current act to see how it's modified insofar as the existing provisions of the various acts and ordinances that have been passed previously. Next, please. There's a provision in section 3 where there is, if there's a conflict or inconsistency between the provision of this act and the written law, then the provision of this act shall prevail, and the conflicting or inconsistent provision should be superseded to the extent of the conflict or inconsistency. So this provision under this temporary measures act will supersede to those provisions under the act or ordinances which I have highlighted to you earlier. Next, please. There are 19 parts of the act. Each part has its own commencement date, and to continue and it continue in operation up to a certain date. Let me take example part 2. Part 2 is an inability to perform contractual obligation. It begins on 18 March 2020 and ends on 31st December 2020. Section 7 of the part 2 says inability to perform because of the measures taken under the COVID shall not give rise to the other party exercising his or their rights under the contract in the schedule. But there's a saving provision, which is under section 10, which says that whatever you have taken, actions you have taken until the date of publication, 23rd October, it'll still be deemed valid. Okay, so this is what you should take note of in respect of the what it does to various parts and various sections. For example, part 3, the limitation period in section 6 of the Limitation Act is extended until 31st December 20. If, say, the limitation expires anytime between 18th of March to 31st of August, then it's deemed extended up to 31st of December 2020. Part 6 on Public Authorities Protection Act, It also extends the limitation period. If it's supposed to expire on between 18 March to 31st August, it extends the limitation period to 31st December 2020. Part 7, there's a provision under Section 20 which says you cannot file bankruptcy petition for those owing up to 100,000. More than 100,000 only you can file bankruptcy petition. On hire purchase, Part 8, Section 23, you cannot repossess if default of installment from 1st April 2020 to 30th September 2020. So any default of the installment payment, it doesn't give you the right to repossess, doesn't give the right to the finance company or the bank to repossess the car. Part 10 deals with Distress Act. You cannot proceed with a distress of a particular premise for areas of rent from 18 March to 31st of August. It's totally not allowed. For housing development control and licensing provision, which is Part 11, if you fail to pay the installment due between the period of 18 March to 31st August, then the developer cannot charge you late payment charges. Likewise, you're not entitled for liquidated damages for delivery of vacant possession if it happens within that period of 18 March to 31st August. Likewise, the defect liability period under the Housing Development Control and Licensing Act, if the defect liability period ends within 18 March to 31st August, then it's deemed extended up to 31st of December 2020. This is what the Act actually provides for. Back to Section 7. Section 7 is under Part 2 of the inability to perform contractual obligations, and which has given you what it modifies. But it also goes on to provide for mediation in this particular Part 2, where parties can go for mediation in respect of those contracts, list of categories of contract, which is fall in the schedule under Section 7. And I will come to that. Can I have next slide, please? Section 9 says any dispute in respect of any inability of any parties or parties to perform any contractual obligations arising from any of the categories of contracts specified in the schedule. In this part, due to the measures taken under the Prevention and Control by Infectious Disease Act, may be settled by way of mediation. Next. Next, please. Okay. 9 sub 2 says minister may determine the mediation process, appointment of mediator, role and conduct of mediation and the current process which the minister had exercised is the setting up of the Pusat Mediasi COVID-19. I'm not going to touch how it works because this will be addressed by Mr. Sufian Hassan, but suffice for me to say that what has happened is that upon the Pusat Mediasi COVID-19 being set up, the Pusat Mediasi COVID-19 is now working together with the Malaysian Mediation Centre in providing the appointment of mediators and so on. So I think Mr. Sufian Hassan will then tell you how the process takes place. Next, please. Upon conclusion of the mediation and the reaching of an agreement by the parties regarding a dispute, parties then will enter into a settlement agreement, which shall be in writing and signed by the parties. Next, the mediator will then authenticate the settlement agreement, and each party will be given a copy, and the settlement agreement is binding by the parties. Next. I mentioned to you the list of categories of contract, which is under this part where the mediation process is supposed to take place in respect of issues regarding the nature of contract. It gives you a list of categories of contract. It involves construction work contract or construction consultancy contract and any other contract related to the supply of construction material, equipment or workers in connection with the construction contract. Performance bond or equivalent that's granted pursuant to a construction contract or supply contract. professional services contract, like legal firms, architectural firms providing professional services, engineering firms, surveyors providing professional services, comes under this category. Lease or tenancy of non-residential immovable property. For lease or tenancy, it talks only about non-residential immovable property. So residential property doesn't come under these categories of contract where parties can go for mediation in case there are disputes. Next, please. Even contract for the provision of any venue, accommodations, etc., also come under the list of categories of contract which parties can go for mediation. Next. Contract by tourism enterprise as defined under the Tourism Industry Act, and also religious pilgrimage related contract, like those Muslims who have booked Umrah trips to Mecca and Medina. If their program has been cancelled, then if there are problem with the organizers, then they can come to the mediation center to resolve this dispute by way of mediation. So that's what the COVID-19 Act provides for. If you have questions on that, then please ask at the end of the session. In the meantime, I also would like to touch the rules of organization. I have decided to provide you the rules of the Malaysian Mediation Centre, which govern the mediation under the Malaysian Mediation Centre. Actually, the Malaysian Mediation Centre was set up in 1999. We have been in operation for more than 21 years. A lot of people are not aware. Some still think that we have not really taken off. Actually, we have been doing mediation for the past 21 years. We have trained more than 600 mediators, and these mediators are also being appointed by the COVID-19 Pusat Mediasi to be the mediators for those disputes that come under the COVID-19 Act. Basically, our rules provide for the agreement of the parties, whereby if the parties agree that their dispute to be resolved by the Malaysian Mediation Centre, then automatically the Malaysian Mediation Centre rules will apply and be part, if it's part of the agreement. Next, please. How do you initiate mediation? Under the present COVID-19 provision, which you will hear from the speaker, the COVID-19 mediation, if parties want to mediate under the present provision, they go to the PMC 19. PMC 19 then will go through with them, and then they will request the Malaysian Mediation Centre to appoint a mediator. Okay, this is a bit different from our rules. For our rules, they can come direct to Malaysian Mediation Centre. They can do a joint submission, both parties, or if only one party wants to have the dispute mediated, then they can file in a request for mediation. And for both these, when you find a joint submission or for request for mediation, you submit a processing fee of 100 ringgit. Next, please. Then once we receive, the Malaysian Mediation Centre receive the request with the payment, then we will contact parties involved in the dispute and attempt them to obtain a submission to mediation within 14 days. If they agree, then we'll proceed. If they do not agree, then it ends there. Next, please. The joint submission for the request for the mediation must also contain a brief statement of the nature of the dispute and give the name and address of all the parties. And the initiative party must file 2 copies of the request and 1 copy with the other party to the dispute. Next, please. The mediator will be appointed by the parties. What happens is that if a party filing a request for mediation and we, the center, having spoken to the other side and the other side have agreed to go through the mediation, then we will provide a mediation kit, and the mediation kit will have a list of mediators. And these are the list of the mediators on the panel of MMC. Then the parties can then agree upon a particular mediator to mediate the dispute, and this agreement must be done within 7 days. If they are not able to do it, then the Malaysia Mediation Centre will appoint a mediator to mediate. Next, please. There's provision in the rules for disqualification of mediator. This is limited to the mediator will be disqualified if he has financial or personal interest, and we want them to disclose if they do prior to being appointed as a mediator. Next, please. Next, please. Parties who come before the Malaysian Mediation Centre need to enter into mediation agreement. The mediation agreement can be found in the kit which we provide to parties when they request for mediation. If during the process there's a vacancy of the mediator is unable to proceed or serve, then MMC will appoint another mediator. Next, please. Representation is important. Normally, if it's a dispute involve individuals, then that person should attend. But if it involves a company, then the person who is going to represent the company attending the mediation must ensure they have an authority to settle. So an authority to settle is a very important component during the mediation process. Next, please. We will fix the date and time of place of mediation. They also need to give us the brief statement where the identification of matters in dispute and exchange of information will be done by the parties. Next, please. As you say, as all of you know, the authority of mediator, we do not impose a settlement on the parties. Basically, the mediator will assist the parties in resolving their dispute. Next, please. If parties are able to resolve, then they will enter into a settlement agreement. This is binding on the parties as provided under the Mediation Act as well as under the present Section 9 mediation. One of the most important provision of a mediation is that all mediation sessions are private. Next. Confidential. Next. No stenographic record or audio-visual recording allowed. When you request for the mediation and we proceed with the mediation, it doesn't mean there's a stay of proceedings. So they still can commence filing a matter in a court of law or going for arbitration. Next, please. The mediation may be terminated upon execution of settlement agreement, or where the mediator himself declares that there's no further effort of mediation is worthwhile, and the mediator will call the mediation off, or if there's a written declaration of parties to the effect that mediation proceedings are to be terminated. Next, please. There's also exclusion of liability. Mediators are not liable, and we are also not be brought into the judicial proceedings. And if you do, then we will appear as a witness, and we will not able to disclose anything, as most of the documents would have been destroyed after the mediation process. Interpretation and application rules are as provided under the rules. Next, please. All expenses must be equally borne by the parties. Next, please. Stamping of agreements is not compulsory, but we leave it to the parties. If parties want to enforce it through the court, then they have to have it stamped. That's all, Samrith. That comes to the end of my topic. Thank you.
Thank you very much, Dato, for your very interesting insight to the Malaysian COVID Act and the Malaysian mediation rules. Was quite a elaborated account of how it's done and how it takes place. Without much further, will introduce our second speaker, Mr. Muhammad Sufian Hassan. Mr. Sufian Hassan is from the Malaysian Prime Minister's Department, the Legal Affairs, which oversees the administration of the COVID-19 Mediation Centre, recently established by the government. He has recently been appointed as the manager of the COVID-19 Mediation Centre. He started his career as a civil servant in 2004 and had the opportunity to work across multiple ministries, departments, and agencies, and holding several different portfolios, including the department administrator and as diplomatic officer. Having a background in integrated construction project and public management helped in developing his current career path. Mr. Sufian will give us an insight to what the COVID-19 Mediation Centre is all about, what it offers, the eligibility criteria, and the updates on the current efforts and recent experience. Mr. Sufian, over to you.
Thank you, Ms. Samrith. Can everyone hear me?
Yes.
Can everyone see my slide? All right. Okay. Thank you again, Ms. Samrith, for the brief introduction. And my name is Sufian. I am the manager of Pusat Mediasi COVID-19 of PMC 19. So I'm pretty much new kid in town actually. So I'm here to share on the Malaysian government initiative on mediation to help people to start over with COVID-19 pandemic. So before that, I would like to thank previous speaker Datuk Kuthubul for on his topic 8 to 9. It was a very enlightening topic, and then it relates so much with our next topic, which is my session. I would like to I would thank the organizer EIADR for inviting us to share on the latest initiative taken by the government. All right, here we go. Okay. Okay, my presentation briefly covers these aspects. First of all, what PMC 19 is all about, and what we do to help people with those related caused by COVID-19. And then I'm going to share on related law that tie us up with PMC 19, which is pretty much covered by Dato Kuthubul just now. And I will share also a little bit on the mediation process, especially on how the setting up of the application for the mediation under PMC 19. And I will also touch on the subsidy arrangement for those who are eligible for getting subsidy from the government of Malaysia. And last but not least, I'll share on the timeline of our operation for this PMC 19. First of all, what is PMC 19? PMC 19 is actually an abbreviation of Pusat Mediasi COVID-19. We are a small unit under the Jabatan Perdana Menteri or Prime Minister's department. Okay, this is actually who we are. We are a small unit under the Prime Minister's department. We are currently a team of 14 manpower. Our office is currently situated in complex Jabatan Perdana Menteri, Prime Minister's complex in Complex B, Putrajaya. Okay, we have a small office there. Our setting up is a task force based operation where we'll be operating for a short time of period only, which is from 16. We have already started pretty much for one month. Okay? Starting from 16 November 2020 up to 16 November 2021. This is what has been agreed by the cabinet. And at PMC 19, we cater specifically for COVID-19 related dispute cases. Okay, other than that, we do not accept this which is out of the dispute cases. Okay, and we report directly to the Director General or DG of Legal Affairs Division or PHEU in JPM. Our office is in Complex B, level 4. So maybe one time, any of you can have maybe becoming one of our mediator, then we have chance to come to our office, and we were welcoming at any time. And so what do we offer actually? So first, just like any other mediation institution, mediation service provider, we are providing same benefits such as a quick solution, which is well known for mediation. We also closed door and private negotiation. A mediation also same as any other, which is voluntary. We offer win-win situation, and also like any other mediation, it binds all parties. But what do we differ actually here is that we focus on the COVID-19 related disputes only, okay? Meaning that cases which is occurred last year, for example, or before COVID-19, before PKP, before MCO, so we would not receive kind of that cases. Other than that, we offer cheaper mediation rate compared to others. This is I mean, cases coming to us is still being has to be paid for some cases, and our charge rate is 2,000 ringgit per session of 4 hours of per day. So on top of that, we do not impose any registration fee, unlike any other mediation center. They may impose some registration fee for fees coming to them. And the biggest benefit of all that is that PMC19 is at PMC19, government is providing subsidy for those who are under B40, M40, as well as small SME, small medium enterprises, which is under small and micro category. So I will share on the subsidy arrangement for those B40 and M40, as well as SMC under small and medium category in the next slide. This is related laws that are tied up to our mediation sector, which is pretty much covered by Dato Kuthubul previously. PMC19 is governed by temporary measures for reducing the impact of coronavirus disease 2019 of 829. This act was passed in the parliament, the previous sitting. It was gazetted on October 23rd, 2020, for 2 years. They are all like being mentioned by Datuk Kuthubul. They are all together 19 parts, and the MC setting up is under part 2 of this law. You can see here that section 9(2) Act 829 empowers the law minister to establish PMC19. So the minister may determine the mediation process, which includes the appointment of mediators, role of mediators, conduct of mediation, and conclusion of the mediation. Therefore, it means that Mediation Act 2012 or Act 749 does not bind mediation under this PMC19, even though most of the setting up for the mediation under PMC19 actually is quite related or in line with the previous act, which is Mediation Act 2012. And for this matter, we came out with our own PMC19 rules to have mediation run smoothly, and we will make it available in our website very soon. This is the list that the list under section 7 Act 829, list of categories that can be brought over to PMC19 for dispute resolution. The number one is construction work contract or construction consultancy contract, and any other contract related to supply of construction material, equipment, or workers in connection with construction contract. Number two is performance bond, equivalent to number one category, and number three is professional services. contract, which is has been listed out by custom department, such as lawyers, accountants, architects, surveyors, engineers, and those are under the list of custom. And number four is lease or tenancy of non-residential immovable property, which is lease of tenancy regards to commercial premises actually. And currently this number four, this category is the most the high the most cases that is coming to us right now. Number four and number five. And number five is event contract for promotion of any venue, accommodation, amenity, transport, entertainment, catering, any kind of events actually, including meetings, conferences, exhibitions, sales, event, concert, and this catering business. For example, we receive a lot of cases, dispute cases for wedding events. Just now in the afternoon, so someone came to our office to refer his case also about this wedding events. Number six is contract by tourism enterprises, that refers to tour package that mostly halted by COVID-19. And number seven, religious pilgrimage related contract, just like being shared by Dato Kuthubul, those who are mostly went or planning to go to visit Mecca and Medina.
Just Sufian, you probably have about 1 to 2 minutes.
Sorry?
You have about 1 to 2 minutes left.
Oh, sorry. Okay. I share on the term of application. Number one is the applicant is Malaysian citizen, and number two is this dispute occurred in Malaysia. Number two, the dispute amount is not more than 300,000. Those cases coming to PMC19 cannot reach more than 300,000 in dispute amount. Number three is dispute occurred in Malaysia. Number four, both parties agreed to resolve to PMC19. Number five is not a bankrupt person or winded up winded up company. Those who have been declared bankrupt or winded up companies need to have sanction from the Director General of MDI, mentioned Department of Insolvency. And number six, business entity registered in Malaysia, or if they apply under business category of business. And number seven, B40 M40 individual or business registered as micro and small and are eligible for subsidy. This is our partners. We have right now, currently we have Malaysian Bar in Peninsular Malaysia. We have Sabah Law Society in Sabah and Advocates Association of Sarawak. So these our partners will provide us a group of mediators to get this initiative running smoothly. This is roughly about the process. Divided into four categories. Number one and number two. Number one is application mainly through a system. So whenever they need to apply for mediation in our PMC19, they have to apply to a system which is is reachable through our website www.pmc19.gov.my. This is mediation venue setting up. They can choose whether to use their own premises or they can apply for government premises. If they prefer to use their own premises, they can just indicate it in the system. And if they would like to use government premises for mediation proceeding, they can inform us so that we can do some initiation to that. Okay. This is about a subsidy arrangement. We have categorized into two, category A and category B. For category A, dispute amount is between 1 ringgit to 150,000 ringgit. We provide with one session, and the subsidy amount is 2,000 ringgit maximum. And for category B, dispute amount is 100,000, 150,000 and 1 ringgit, and maximum is 300,000. We provide up to 4 sessions of mediation or 16 hours, and also the amount of subsidy is between 2,000 ringgit and 8,000 ringgit. These are subsidies, as I mentioned just now, to those B40, M40, as well as SME under small micro category. This is the timeline. We'll be operating for 12 roughly 12 months from last November. So we will end up our operation in 15, 20, 21. But depends on the decision from the government whether they are going to extend it beyond the earlier proposed plan. This is what we have been doing. So we went out to TV and radio. We are currently doing all out to go to reach out the public, and within this next 2-3 months we are going to reach out all over the country, okay, for our promotional program. And this is our website, www.pmc19. Feel free to visit our website, and public can visit this website to look up for what PMC19 is all about, and also they can apply to links that are available in this website. Also, please do not forget our Facebook page, Pusat Mediasi COVID-19. I think that's all for me.
Thank you very much, Mr. Sufian, for the very interesting and very, I'm sorry to have rushed you. It was so much more, I think, to gain from you, especially this being a very new area for most of us. Thank you so much for what you have offered. I'll quickly move on to our third speaker, Dr. Noorfajri Ismail. Dr. Ismail is currently a senior lecturer attached to the Faculty of Sharia and Law at Islamic Science University of Malaysia, USIM, lecturing dispute resolution. Prior to that, he was in practice, where he was a senior associate in litigation and dispute resolution practice group with Azmi and Associates, and also lectured at the University Kebangsaan Malaysia and University Technology Malaysia, specializing in ADR. Earlier in his career, he served as a magistrate as well. Dr. Noorfajri Ismail holds law degree from UKM and obtained his Ph.D. from University of Malaya in 2018. He was called to the Malaysian Bar in 2008, and he is currently an accredited construction adjudicator and is in a panel of adjudicators of AIAC, and has been appointed by the director of AIAC in few cases that relates to construction contract payment disputes. Dr. Ismail will take us through the emergence of e-mediation and its applicability, which is now becoming a norm. Doctor, I pass on the mic to you.
Okay, okay, thank you very much, Samrith. Can you guys hear me? Right, okay. Okay, I'm having problem sharing my slides. If Apri can share the slide, can share my slide, Apri, please. All right, thank you very much. Thank you, Apri. Right, without further ado, thank you again. And my topic would be the emergence of e-mediation and its applicability. I'm sure that you guys can see my slide here. So yes, if we are moving into my first slide. Next slide, please. Many of the reasons actually for us using online mediation in 2020 are unique to the time in which we live. And as the coronavirus made it rapid and implacable, advance across Malaysia and the world, forcing sweeping closures of school and workplaces and also courthouses, and bringing about the disappearance of any type of collective and real world activity, it became obvious that a new era had begun. And many of the assumptions pertaining to in-person mediations have never really been tested before, and replacing face-to-face human interaction with virtual face-to-face contact represent a sea change for our justice system. With the passage of time and the accumulation of experience, there will be a sorting out, and we will, I think, be left with a revitalized way of mediating disputes. And now seems an ideal time to thoughtfully test our assumption with the intention of keeping the ones that work and discarding the ones that do not. Next slide, please. Well, online mediation or e-mediation was originally thought as a way of bringing the justice system to citizens who could not get to the place where the rule of law was resident. E-mediation relies on the fact that cell phones are in the world of its own, even for people who struggle to meet the most basic of human needs. And with a cell phone and then with smartphone, human technology, human rights group helped develop the technology that for the first time brought the justice system to the people. Well, another incubator for online dispute resolution has been an e-commerce. Very early in the development of online companies like eBay and Amazon, they were forced to respond to a volume of disputes with their customers and business partners that would have overwhelmed a conventional customer service operation. And as a result, these companies looked to artificial intelligence and other technologies to develop algorithms that could resolve disputes in ways that took into account vast amounts of experience expressed as data and settle dispute in ways that seems to human customers fair and reasonable. Next slide, please. Well, you can see that online medium for mediation, you can see that in early 2003, Skype entered into the online meeting market with 100 million users up to March 2020, followed in short order by Facebook a year with 2.7 billion users recorded as June 2020, and then come WhatsApp in 2009 with 2 billion users as of February 2020. And believe it or not, Zoom, the platform that we have for our forum today, has been around since 2012 and went public only in April 2019. And with coronavirus hit in January 2020, Zoom went from 10 million daily users in December 2019 to 200 million daily users in March 2020, while Google Meet made an appearance in 2017 with 100 million users daily in April 2020. Next slide. The internet has become more or less indispensable business resource as more companies rely on the online tools. As more businesses shift towards a digital environment, it may be time for mediators to do the same. And online mediation or e-mediation could help you meet client changing needs in an increasingly digital workplace. E-mediation is not a new concept, but recent events do put new emphasis on it. And thanks to COVID-19, many companies have shifted to a work from home approach and moving much of their work online. And as you are undoubtedly aware, just because people aren't in the same physical space, it doesn't mean workplace conflict is gone. Under the stresses, all the stress that we have in 2020, mediation is arguably more crucial than ever, and the traditional approaches to conflict resolution may not always be available or effective right now, though in light of situation, you may want to consider online mediation. The most important issues on the online mediation would be reliability and the security, as it is essential for an effective online mediation, and with most law firms, businesses, and mediators presumably already set up to work remotely, the primary technical requirement for each mediation participant is an internet-connected device, preferably Wi-Fi, mediation with video and audio capabilities. And in terms of mediators hosting on the mediation, services can be configured for multiple rooms, like a conference room for all parties within or with a separate caucus or breakout rooms for the individual parties. Therefore, as a host of a meeting, the mediator can enable various functions to ensure the security and also the confidentiality as well, in which, for example, when creating the meeting, The mediator should include 2 layers of security, for example, namely a password for each participant that must enter when accessing the meeting, or a waiting room function that will allow the mediator to admit participants into a meeting once they log in. Therefore, this is depending on the mediator as a host. The Zoom alternative the Zoom alternative puts the lawyer in a familiar space with ready access to their file and stuff. So this is somehow or rather streamlining dispute resolution processes in which they can employ technology to fortify their negotiating in ways that might be challenging away from their office. If nothing else, electronic mediation tools can streamline the conflict resolution process, and you can use document sharing services to make filing any paperwork faster and more straightforward. Next slide, please. This is some of the latest development on the online mediation that we have. For example, for Singapore Mediation Convention 2019, you can see under Article 4.2, in which give the recognition towards the electronic communication that can be included as required for the settlement agreement. And for the AIADR mediation rules recently 2020, there is actually 2 rules in which Rule 8.5, which allow pre-mediation and also mediation meeting that may be conducted via teleconferences, video conferences, or any other electronic means or secure digital platforms. And under Rule 9.2, settlement agreement may be recorded by electronic means and executed by way of digital signature. So next slide. Well, if you are discussing about conflict resolution in the digital era, remember that you don't have to use every tools that are available to you depending on the situation. It may be best to meet in person, or you may want to have a video conference instead. And you shouldn't use online services because you can, but because they can improve your mediation process. Like any other mediation attempt, you will have to approach each case on an individual basis, and every instances of conflict will have different needs, so your tools and techniques may vary. Yes, to serve everyone as best as you can is something that you keep in your mind, and you have to be open about what online mediation looks like for you. And if you can see that what is truly unprecedented about this moment we find ourselves in today, in the depth and breadth of the changes that have already happened, and it is a game changer, as a mediation practice should embrace technological disruption, and technology can often be a double-edged sword, and it can be a point of stress and high emotion for people, but it can also help relieve tension. As a mediator, you shouldn't shy away from technology, but use it with care. To conclude, online mediation is not the answer for every problem that you will encounter. It can help conflict resolution become more versatile, effective, and convenient. And that's all from me. Thank you very much.
Thank you very much, Dr. Noorfajri. Indeed, we are in interesting times, which we never would have imagined how fast we would have to adapt or adjust to use these online platforms. We have seen a number of institutions coming up with their protocol to assist in a smooth running, I think, in the mediation, online mediation process. We move to our next speaker, our Dato Seng Huat, who is the Honorary Secretary of the Council of the Justices of Peace in the state of Penang. A chartered governance professional, he has almost 50 years of working experience, which includes naval engineering, building construction, managing consultancy, and educational development. His credentials include a Master in Business Administration, Business of Jurisprudence, and a graduate of Royal Institute of Surveyors Malaysia in Quantity Surveying. He facilitated the training of local community mediators since 2016 and played a key role in establishing of the JP's Mediation Bureau in 2017, which provide pro bono mediation services to the local community in Penang. Dato Ong is also a pioneer member of AIADR. Dato Ong will share with us his experience in community mediation during the pandemic, how the justices of peace became involved in being trained as mediators and their visions to help mediation community generally. Dato Ong, over to you.
Thank you very much.
Thank you very much, Samrith. Apri, can I have my slides, please? Now, mediation, and the word mediation, I've done my homework, I've done some reading. Mediation. We know that mediation starts in the early civilization all over the world, across the world. It's not just only in our part of the world. So the word mediation is actually a common word. I mean, it's in English, but it's the meaning is there. And I always like to start with mediation itself. The actual meaning of mediation is actually community dispute resolution. It starts as a community dispute resolution. Malaysia being truly Asia, all right, it's a melting pot of Asian values, culture, and traditions. So this is where I want to share with you the history of mediation in Malaysia. Next slide, please. Next. Next. Next slide. Now, community mediation in Malaysia in the early period, before the arrival of the British administration. All right. My record shows that as early as 15th century, all right, before the arrival of the British judicial system, 1807, the local inhabitants, the locals, have already been practicing this, what do you call that, mode of dispute resolution. For the Malays, predominantly Muslims, it's called suk, which is in Arabic, end of an argument or compromise, translated as conciliation. Now, those days, the mediators were local chiefs, imam, penghulu, ketua kampung, and most of these people are appointed by the sultan, the state sultan. Whereas for the Indians, they practice, predominantly Hindus, practice the system from India, panchayat, which means a village council, group of elder acknowledged by the community as the governing body, respected, of course, and they are the decision makers for all the dispute issues of the villages. The Chinese who came later, on the other hand, adopted in Chinese, it's called tiaojie. Tiaojie, literally translated, means mediation. And this mode has been the primary mode of dispute resolution even back in the thousands of years in traditional China. And it's been traced to by the philosophy of Confucianism. That's why you say Asian forum, I think, is relevant. And you talk about Japan, Korea, all right, all this. And very interesting okay, next. Okay, it's okay. Next. Now, Penang is not a sultanate. Penang is not a sultanate. The history trace, the modern Penang trace is 1786 when the British came in. Right, when the British came in Penang, when the British came in, they appoint JPs or Justice of the Peace, which is actually common which is actually a copy institution from UK, from the Great Britain, right? And these Chinese who are migrant, the Baba, if you are talking Malaysian, you understand they are actually the Baba and Nyonyas already. They are educated. Apart from being businessmen, entrepreneurs, or politicians, they are actually appointed also as a mediator. They resolve local disputes. And if you were to look at the history, even rights, that means very serious, what do you call that, communal disputes. Now, after 1948, when Penang joined the Federation of Malaya, all right, the appointment of JPs has changed. But then the Subordinates Court 1948, all right, provide two provisions very clearly about JPs. 98, section 98 is the appointment of the Justice of Peace. That means the act is still there. It's not repealed. The act is still there. It's still valid. 99 is the power of the JP, not to the what do you call that, the second-class magistrate. The question here is why we are not in the magistrate. That will be another topic to discuss. And there are since no new appointments. Next slide. Next slide. The Bureau. Now, after 1948, independence in 1957, and then Malaysia in 1963, new It's a new nation, it's new laws, new enactment, new legislation. Now, all the new laws, new legislation will supersede or take precedence over the ordinance that was practiced by the state settlement at early Penang. All right, then the role of JPs diminishes. All right, or rather the power has overlap. And today we have a lot of educated people who can become magistrates in the judiciary administration. So what we did was in 2016. So we thought that, hey, after all, we are still recognized under something called 1948, Section 98 and 99. So we do have that kind of judicial, we do have the quasi-judicial power. Why not we go into mediation? So in 2016, we were lucky. We were able to convince AIAC, the Asian International Arbitration Centre, which at that time, the director is Datuk Sundra Raju, at that time was Datuk Sundra Raju, to actually endorse us. That means we need recognition. So to get the trainers, And over the few years, this year we don't have any training because of the pandemic. We have actually trained media. Now, our concept of mediation is different because we talk about community. We have to reach out. So we select, other than our JPs, we present non-JPs, community leaders to join us. And so the background can come from medical, legal, engineer, construction, finance, trade, commerce, and other industries. And two of us, JPs, at that time when the court circular 2016 came out with annex mediation, we were invited, myself and Dato Sri Makan, we were invited to actually conduct mediation in court annex mediation. So we had the experience of doing that. So we thought that there's a community gap. Institutional mediation is to talk about all the rules. Community mediation is lacking. So we thought that we should put a proper structure. We call it a bureau, and we get the Tuan Yang Terutama, the governor of Penang, to launch, so that when people recognize you, the confidence will be there. All right. At the moment, the bureau is managed by 15 JP and non-JPs. When I say the word manage means we do have ready the trained mediators to take cases. Next. Now, the word mediation legally, like I said, mediation is actually a general word. When we learn what we learned in school or in law earlier, mediation is one of the ADR not binding. Not binding, that's what. But then the word binding comes in later. I like to use the word later. If you look at the progress of the Malaysian law, now the community mediation was initiated by the Department of National Unity. National Unity was previously under the JPN's department, Tuan Sufian, dulu JPN. To this year, under the new government, Department of Nationality has taken out from the Prime Minister's department, has now moved to a new Ministry Unity Department. They've been training community mediators 2007. Now, but their community mediators is concentrated on, or within their neighborhood, the Rukun Tetangga. And interestingly, in 2012, when the community mediation, the Mediation Act was enacted, the Rukun Tetangga Act also enacted, 2012 same year, same date gazetted. All right. So it becomes recognized. Section 8 recognized the RT, and mediation becomes a part of the absorbed into the system. All right. Rukun Tetangga Act 212, Mediation Act 212. And I like to add the word COVID-19, COVID-19 2020. It means finally, that's my personal view, Tuan Sufian. It means finally the government is recognizing the very important word mediation. It must be put in with some legalistic, legal interpretation. Next. Now our response. Now, pandemic, nobody can come. The CMO, nobody can come out. Our center was closed, and the Director General of Health advised us, people of my age, stay home, stay safe. So we are not moving out. So how do we reach the community? So we approached the Chief Minister of Penang. We need his voice. We need his channel. We need his voice. We need his channel. So we did a webinar with him as a guest speaker, with Mr. Taruma, the Bar Council, then the engineer, the MMCs, the adjudicator, and myself. All right. Then we reached out. We reached out to this community. All right. But that was before the COVID-19 the bill was gazetted. Before it was drafted, but not yet gazetted. Next. We are very happy to say that our explanation to the Chief Minister, or rather what we would intend to achieve, the Chief Minister echoed our call. In his speech, he translated our intention, and then he set it up as a speech. And his speeches are printed in the newspaper, printed in the government media, and in trilingual. All right. What he says is that in embracing the new normal together with the new paradigm, that's a new, the Chief Minister urged the various industry sectors and trade association leaders, that's community leaders, to take the lead in encouraging their community members to choose mediation over other dispute resolution. This is our approach, community mediation, to resolve contractual dispute, private or commercial, inclusive, to mediate and not mediate. In fact, I will encourage the business committees through their respective trade bodies or associations to set up their own in-house. Why wait? Why wait? You can start your own. And he has asked us, the JP, to assist. We have no problem. And we are doing that. And the government actually, for the court, the state government is very supportive of our work. Although they cannot provide us a so-called premise, they cannot provide us the kind of financial resources, but definitely they give us very encouraging support. And I like to say at this point of time, we have two organizations responded to this. That means two organizations will have their own initiative to help to settle their own members. Members means the community, all right? Dispute through, we treat as community mediation dispute. Next. All right. I like this word to keep in people's mind. All right. Mediation originates as a mode in community dispute resolution. Any other thing is called alternative. Mediation is not alternative. And mediation is the dispute resolution to us as a community mediators. All right. And I dare to say to the distinguished panelists down there, to the ordinary citizens community in Malaysia, to them, when they think of mediation today, they think of another legal fighting, or just get the fighting of a lawyer. Mediation should be always think of self-help. Mediation is nothing more than assisted negotiation, nothing more than facilitated negotiation. So whenever there's a dispute, sorry, somebody mentioned about the lawyers' rights book. The communities must first start on their own first, self-help, and resolve their dispute. Failing which, then we move to the experts like lawyers and whatever. Well, next, please. Now we like I said, we don't have the kind of financial resources, but we are trying very hard. So we have our bureau website, and then in anticipation of the COVID-19 mediation from response from the community, what happened is the complex Penang, those of you from Penang will know there's a complex Penang where we have our office. Today is out of reach because of the COVID-19 has turned into a temporary hospital for the light cases. So we have actually one of our members who's a quantity surveyor allow us to use the place. All right. So for those of you who feel very strongly subscribe to what we believe, that you can help yourself within, especially when the two disputants are close to each other, neighbors, relatives or not. Whether you go to court, of course, when you go to court, you're talking about win and lose. You talk about ADR.
You have to wrap it up. We are running out of time.
You talk about ADR, then you're talking about you are coming to a compromise or to an agreement. So why don't you two of you solve yourself? And that is some message that we must send to the communities. All right, thank you.
Thank you very much, Dato Ong, for sharing with us the JP Penang's initiative to train as mediators and to help the community in mediating their disputes. Our next speaker is none other than Mr. Dato, who is the founder, partner of Thailand DTL Law Office and is currently Secretary General of the Thai Chinese International Arbitration Centre, also known as TCIAC. TCIAC is the Alternative Dispute Resolution Centre, which is established to support alternative dispute resolution in commerce and investment between Thailand and China. He is the Chinese representative of the Thai Arbitration Centre, a member of the Arbitration Committee of the Thai Chambers of Commerce, an honorary advisor of the 2nd District Police Station of Thailand, Director of Thai Chinese Enterprise Chambers of Commerce, Vice President of Thai Youth Chambers of Commerce, Vice President of Thai Chinese Association for the Promotion of Peace, Reunification Executive. He holds a master's degree from City University of London and has more than 18 years of experience in practice, mainly specializing in foreign investment, mergers and acquisition areas, and providing dispute resolution solutions. Mr. Shi will share his vision, thoughts, and views on institutional collaboration as was done with the Thai Arbitration Centre known as TCAMC and benefits of its collaboration. Mr. Chi, please take on the mic.
Thank you very much, moderator. Can you hear me, yeah?
Yes, we can.
Okay, good. So today, before, I want to apologize first because my computer have a problem with Zoom. I'm not in my office, so today I cannot use my PTT. All right, so today my talk will be the possibility arbitration institution collaboration between China, Thailand, Malaysia. So all this today, what I share with all of you is based on my, oh, you have this, that's wonderful. I think I don't have it. Okay, wonderful. Okay, so it's based on my practice experience in Thailand. So actually, I'm a Chinese lawyer. I came to Thailand 2014. They set up a DTL office almost 6 years. And this year, we set up TCIAC, Thai Chinese International Arbitration Mediation Centre this year. So it's my pleasure to, to share my practice experience with here. So please move to next page, please. So yeah, so today most as our speakers talking about mediation. So mediation, I think is very good dispute resolution. Now I would like to focus more about arbitrations. As as we know, arbitrations can be recognized in 163 countries, including China, Thailand, according to New York Convention. So there are some advantage of arbitration, like for example, parties ultimately, the concerned party have the freedom to choose its own arbitrators, language, and then as well as applicable law, and also when arbitration award is final, so it will become effective. The concerned party is not allowed to appeal in the case. It takes only short time to receive arbitration award. And very important is that arbitration is confidential. The arbitration proceedings are not carried on publicly, so that the concerned parties' trade secret and reputation are protected. So it can be recognized and enforced internationally. Please move to next page, please. So normally, as I practice in Thailand, because our firm TCIAC also, we mainly focus on Chinese, Thai international trade, investment transactions. So based on my experience, so which country law the Chinese investor would like to select? Like for example, Chinese law, I think most popular, and also Thai law. Then there might be some third country, for example, Japan or Singapore. But even Thailand is the same as China. Is a civil law, but actually, since I practice in Thailand, I operate my law firm here, I discovered that actually even though Thai law is a civil law, but in practice, they are very close to common law. Like they have a witness hearing, they have a cross examinations, they have the step is a big different to compare with China litigation process. So it's quite different. So I think if the parties to to make choice of applicable law is very important because it's quite a big difference. Please move to next page, please. So then we talk about a jurisdiction who have the right, who have the jurisdiction over the dispute. Normally, according to my experience, the first choice maybe they will select in China, like CTAC or BAC or the Guangzhou Arbitration Commission, Hainan International Court. They will select this kind of famous arbitration institutions in China. But sometimes they also want to select in Thailand. But in practice, they may select certain countries, for example, Singapore, because Chinese are not familiar with Thailand and Thai not familiar with China. So they want to balance each other. They would like to select go to Singapore. So it's quite happened in my at this moment in our law firm. At least we have five cases dispute referred to Singapore. So I think during Thai-Chinese international trade investment, so they're gonna select certain country. But however, if they select certain country, there are still many pinpoints I would like to share with you. Please move to the next page, please. Yeah. So we call pinpoints. For example, foreign arbitration award enforcement in Thailand. So first, in Thailand, there's no law prohibited. I mean, the respondent, the applicant apply foreign arbitration institutions to order the temporary petition to freeze respondent property in Thailand. But since Kingdom of Thailand is established, there is no any case that the applicant applied for arbitration institution to issue the temporary petition to freeze the property in Thailand. This never happened. So that means the applicant cannot freeze the respondent property in Thailand during the process of arbitration. So I will be quite often asked from Chinese company, Chinese lawyers, during the process of arbitration in China, whether we can apply for like injunction for to freeze the respondent property in Thailand. So the answer is no, we cannot. So then what a time we can apply freeze the property in Thailand. So there will be, since the Thai court accept foreign arbitration avoid, since that then we apply for freezing properties. So this is we call quite a pinpoint for Chinese investors, because in China it's not difficult as in Thailand compared in Thailand. Then the second one is like in China, if you wanted to freeze the respondent properties, you just pay deposits, at the guarantee. Then the court will probably gonna accept that. But in Thailand, doesn't work. In Thailand, first you need to prove that the respondent have the potential or already transferred property properties that the court may issue the order. Then so that's another big difference. Please move next page, please. And also the very important, so when we take enforcement foreign arbitration award in Thailand, we need to be aware the procedure of arbitration. For example, notice of hearing, this is very important, not just provide the evaluates from the arbitration institutions. We also need to prepare one copy of a notice. For example, the notice of arbitration rules, arbitrators, and also appointment of arbitrators. If we cannot provide this kind of evidence to prove that we have properly delivered our notice to the respondent, the court may reject our application. So also there's another, we be aware conflict of Thai law. For example, if the loan contract, for example, interest in China, the maximum is 24%, but in Thailand only 50%. So if there's conflict in compared with Thai law, so the foreign arbitration award may be adjusted as well in accordance with Thai law. So please move next page, please. So it also, this is gonna be take, like in China, we take normally for foreign arbitration award, probably gonna take 6 months, 1 year. But in Thailand, we have a first judgment hearing, second judgment hearing, probably gonna take 1 year. So it's quite a long time. So, and also for in Thailand, if you want to take enforcement, you know, to notify the arbitration award as well. So this is a quite, we call, you know, I mean, it's like we have the respondent have a right to appeal in higher court. In China, we don't have this kind of a process. In Thailand, it's like a formal litigations. So this is another pinpoint. Move to next page, please. So, but what's different what is different to compare with Thailand and China is like in Thailand, the first judgment, if the first judgment have recognized the arbitration award, the applicant may directly apply to LED to take enforcement directly. So it do not wait for the appeal court judgment. This is quite good for for applicant. Move to the next page, please. So now this year we set up TCIAC, Thai Chinese International Arbitration and Mediation Centre in Bangkok. The reason why we wanted to solve this pain point which I mentioned. TCIAC, please next page, please. TCIAC is co-founded by Hainan International Arbitration Court, HIAC, Thai Arbitration Centre, THAC, and then Thai Chinese Legal Alliance Association. These three organizations set up TCIAC. It's headquartered in Bangkok. Then please move to next page, please. So this TCIAC is resolving economic and trade dispute between Thai and Chinese enterprise. As I mentioned before, many Chinese investors or Thai investors, they select third country dispute, third country jurisdiction over their potential dispute. But as I mentioned, actually Chinese not familiar with, for example, Singapore, Thai not familiar with Singapore. So TCIAC will resolve this kind of pinpoints. So we have a Chinese arbitrators, we have a Thai arbitrators, we have Malaysia arbitrators. So we have a third country arbitrator as well. So it's also funded by Chinese, Thai together. So this TCIAC will balance Chinese, Thai investors. I mean, they don't. I mean, it's not necessary to select third country which they are not familiar with. So TCIAC in Thailand, and also we have a first branch in China is in Hainan, Hainan International Court. We have our first branch there. So Chinese, Thai investor, they can make choice in Bangkok or in Hainan to conduct the arbitration. So it's more freedom for them to select. And also TCIAC in Bangkok, also for Chinese and overseas Chinese through mediation, you know, in independent and friendly manners. This is very important. You know, mediation is as I mentioned, it's like East Asia cultures. It's you know, can make it a short time to friendly to solve the dispute, potential dispute, and when mediation agreement achieved, both parties still, you know, still be friends, still can be political partner, and still can have a future credit. So TCIAC will have this platform to provide mediation arbitration service to Chinese and overseas Chinese in Thailand. And also, third, we also would like to provide guidelines to China arbitration institutions. For example, Hainan International Arbitration Court. We would like to provide, you know, if there is an arbitration case conducted in Hainan International Arbitration Court, then we would like to, you know, to provide our guidelines for them, how they properly issue the deliverable notice to respondents, or, you know, in Thailand, because this arbitration award probably gonna take enforcement in Thailand. So at the beginning, the process, the procedure of arbitration, TCIAC will provide guidelines for you know, the applicant or HIAC, you know, properly deliver the notice of hearing. I think this is the TCIAC, you know, to solve the key point which I mentioned. And then also TCIAC we can select, arbitration English, Chinese, Thai. It's more flexible for Thai Chinese investors, to contact the court, arbitration court, the hearing. And then we also, I think very important, the TCIAC can create more legal professional opportunities in Thai and Chinese. If we, like between Thai and Chinese, if the dispute take place in, for example, Japan, then Chinese lawyers, Thai lawyers, I think it's not the significant lawyers need go to Japan. But if we TCIAC take place in Bangkok or in China, then if, for example, in Bangkok, there will be create more, Thai professional jobbers. For example, they have two-party applicants and also respondent in the Thai lawyers, and the arbitrators from China, from Thai, from another certain countries. So TCIAC will create more job opportunities in Thailand. This is I think it's a very good advantage for all Chinese Thai legal professionals.
Mr. Shi, you may have to wrap up.
Yeah, please. Next page, almost finished. Thank you very much. Yeah. So our objective is to avoid and resolve economic and trade dispute in independent and fair manners. Please, next page, please. Okay, so please, next page, please. Okay, that's all for today. I think TCIAC, we just set up the TCIAC this year. It's quite a new organization in Thailand. We still need to improve ourselves, but I think in the future TCIAC will work very well in Thailand, and I'm looking forward another opportunity to share what is going on with the TCIAC with all of you. Thank you very much.
Thank you very much, Mr. Shi. Thank you for the interesting presentation and insight to TCIAC. We'll move along quickly to our last speaker, Mr. Alex Pan. Mr. Alex Pan is the first president and board member of Hainan International Arbitration Centre, HIAC. He is a practicing barrister in Hong Kong, arbitrator, accredited mediator. Mr. Alex graduated from University of Hong Kong with a bachelor's in law, and after which he had obtained his master's in international commercial law and AKC at King's College London. He's a fellow of the Chartered Institute of Arbitrators. Among others, Mr. Alex is appointed panel arbitrator of Guangxi Arbitration Commission and a panel of mediator of Zhejiang Qihai International Commercial Mediation Centre. Mr. Alex is also appointed as a member and adjudicator of more than a dozen of government boards and statutory bodies and tribunals. Unfortunately, Mr. Alex is unable to be with us in real time, but he has very kindly forwarded his PowerPoint presentation with his recording. Mr. Alex will be taking us through the Hainan International Arbitration Court take and response in resolving commercial disputes during COVID-19 pandemic. The Secretary, can you help us put up the slides?
Good afternoon, everyone. I'm very happy to join this occasion. First of all, I would like to express gratitude on behalf of Hainan International Arbitration Court, HIAC, to join this meaningful event. And I would also like to take this opportunity to thank our joint organizers, including the Asian International Alternative Dispute Resolution, China Asian Legal Cooperation Centre, Malaysia, as well as the Asian Law Students Association. I'm truly happy, and it is truly my pleasure to be part of the panel speakers today. First of all, I would take this opportunity to introduce to you what we are doing and who we are. And we are Hainan International Arbitration Court. As all you know, since 2018, China has implemented a new strategy in developing Hainan into a free trade port. The objective and the target is that we would achieve the status of feature report from 2025 onwards. And therefore, our arbitration court serves an important role in assisting the FTP to achieve that. And HIAC, that is the short form of Hainan International Arbitration Court, we are set up as a permanent arbitration institution in Hainan province. And our primary mission is to provide top quality arbitration service and other services pertaining to commercial dispute resolution for the Hainan FTP, the feed report. And in fact, our basis on and our history was based on the Hainan Arbitration Commission, and we have a reform and a rebrand exercise these few years, and now we have our brand new Hainan International Arbitration Court. As I said, we aim to provide top quality dispute resolution services at international standard. And we are able to deal with civil and commercial dispute resolution, mainly by arbitration and also mediation. Of course, we are one of the arbitration institutions established under the arbitration law, the national legislation for arbitration in China. And our jurisdiction covers all sorts of civil and commercial disputes, except the matrimonial, adoption, guardianship, financial dependence, and succession disputes. And we have we have a number of core objectives we would like to achieve. First of all, we would like to take this opportunity to maximize the potential of arbitration under arbitration law, which can be reflected in our new setting, our new branding, and our new set of arbitration rules and mediation rules. And we also strive to bridge the international arbitration community and the local Chinese arbitration communities. It is also a breakthrough for us, for HIAC, to be established as the statutory body for public interest and formed under the legislation at the provincial level. And it is the first arbitration institution among all in China. And in terms of the governance setting, we are also built on a very advanced structure. And the administration of HIAC is in fact led by a board of directors, and we are a statutory incorporated body. And the board of directors are all appointed by the Hainan provincial government, and we are led by the chairman, Mr. Wang Xuelin, appointed by the provincial government. And under the board of directors, the whole HIAC is led by president, and that is me. I would also say a few words to introduce to you our board members. Of course, I don't tend to introduce to you one by one, but as you see in these photos, this shows the snapshots about our first board of directors meeting held in August earlier this year. And yeah, due to COVID-19, not all our board members could attend the meetings, and some members attended in person, and the rest attended the meetings via online facilities. One very special feature about our arbitration court is that in fact, in the constitutional instruments, it is stated that it is a mandatory requirement. We must have not less than 1/3 board members from overseas. And in fact, we have more than 1/3 board members from overseas, and about 1/3 from the local Hainan province, and about 1/3 coming from the other parts of China. And about the basic situation about the arbitrators, and of course we have a panel of arbitrators, At the moment, we have more than 900, approaching 1,000 panel of arbitrators coming from all places over the world. We have about 21% from our Highland province, and about 54% is coming from the other cities in other parts of China, including Beijing, Shanghai, Guangzhou, and Hong Kong, of course. And we have 25%, one-fourth of arbitrators coming from overseas. And this diverse composition of panel of arbitrators truly enrich our level of internationality. Yeah, now here comes to the a few things we've done during the COVID-19 pandemic, which is still ongoing in quite many countries in the world, but in Hainan our situation is pretty good. So what have we done during this period of difficulties, period of COVID-19? As you see, we have done a number of things. We've done something to strengthen our infrastructure and platform for dispute resolution. It mainly concerns our official launch of the International Mediation Centre, which we will share more with you in a moment. And second, we also continue to build very strong cooperation relationships with the regional dispute resolution institutions, including cooperation on arbitration and mediation, of course. That's why we are here to share with you today. And we have also collaborated some research projects. In fact, it is a mini research project for strategic and practical solution in response to COVID-19. And we still have our ongoing and routine studies visits to different law firms, enterprises, and legal institutions. Of course, we do this to promote ADR service, promote arbitration, mediation services, and also, very importantly, to know the needs of those stakeholders, the law firms, enterprises, and other legal institutions, especially in the period of COVID-19. We also undertook and still undertake a number of relief measures or specific measures for those arbitration or mediation users with our institutions. We decided to reduce arbitration fees for some of the selected sectors, including the retail, catering and accommodation, logistics, tourism, and construction. These are those sectors mostly affected by, or heavily affected by the COVID-19 pandemic. In fact, for these sectors, should they need arbitration or mediation services with us, we also establish a fast-track system for them to commence and file their cases. And finally, it is, of course, an ongoing and routine exercise. We keep enhancing our capacity to provide online service. And needless to say, we have a very strong system of e-filing of application for mediation and arbitration. And we also take advantage of our online system to assist the parties to submit their application for interim measures or measures of pacification to court. As you may know, for the arbitration institution in China, we are part of those institutions set under the or prescribed under the arbitration law of China. And in our country, all interim measures application cannot be directly dealt with by the arbitration institution. Instead, we would act upon the parties' request and application, and we would direct and forward the application and submit the application to the People's Court for the parties, and the court will make a decision on the application of interim measures. So now we can do it online. let me elaborate a bit more about what we have done for strengthening the infrastructure and platform from dispute resolution. And of course, if we are to develop a high quality dispute resolution platform, of course, we need to have some organizational structure. And of course, before the launch of these international mediation center in Hainan, we have been providing mediation services, but in order to manifest our mission to provide top quality DR service for the FTP, and we reform our mediation service, and in these connections we establish and officially launch our international mediation center, right? And we set up and adopted brand new mediation rules. And you know, for the mediation convention and tradition in China, and it mainly evolved around arbitration and litigation as mandated by the court. But under these set of new mediation rules, we try to adopt some of the practice employed in other jurisdictions or countries. Now mediation under our mediation center is something more than the traditional up-med or med-up type mediation. And the existence of an arbitration clause is not necessary. It means that even if the parties in the agreement, if the agreement does not contain any arbitration clause, they can still proceed with this standalone procedure for mediation. But of course, under the existing frame of mediation, usually parties also end up with a settlement agreement, or sometimes if the mediation fails, we still have a mechanism for them to continue the dispute resolution system with arbitration. And by all these, we would like to breach the court litigation and settlement via our new set of mediation mechanism. And under this new set of rules, the mediation is an effective and efficient means to resolve dispute, and it costs only 50% of the arbitration fee which should normally charge for our arbitration service. And under the rules, we also have the 30 days limit to resolve all the dispute by mediation. Of course, we are not going to say the party have to reach a settlement, but we laid down a time frame of 30 days in order to encourage a speedy dispute resolution via the mediation under our new rules. Building our infrastructure aside, we also strengthen our cooperation with regional dispute resolution institution. Among others, we are one of the very first parties to execute a memorandum of understanding with eBram, as you see in the photo, which is a leading ODR company service, ODR service provider based in Hong Kong. And we very much look forward to have further cooperation with eBram in the near future. As I said, we also conducted study visits to enterprises, law firms, and other stakeholders within the arbitration and mediation communities. Yes, this is the research project I mentioned a few minutes ago. And what we did is, it was about, we recruited and organized our arbitrators who are very passionate ones to conduct some mini research, and they wrote a number of articles. We try to draw on and synergize their expertise and specialties in different specific areas. And under these mini research, those arbitrators, they are grouped by expertise and grouped by specialties. They formulate strategic and practical solutions to tackle situations pertaining to the COVID-19 pandemic. And you see, we have prepared and compiled research reports in a little booklet, and we distribute this, our outcome, to the enterprise, the law firms, and the relevant authorities. So this is a very quick sharing of how HIAC responded to COVID-19 pandemic and how we have been doing in this period. Thank you very much. I wish you continue to enjoy the rest of content today. Thank you.
Okay, I hope everyone benefited from Mr. Alex's presentation. We have come to the end of our session. We have run really out of time. I would like to quickly thank each and every one of you, and special thanks to our esteemed speakers from near and far who made it possible for this very interesting and interactive session. I would like to thank the organizers in putting this very interesting forum with excellent speakers. We don't have time actually to take any question, but there's only one question that I can see. If someone can just quickly answer this. Is there a mediation center in Sarawak? Maybe Encik Sufian, would you want to take that?
Ms. Samrith, on behalf of PMC19, I would like to mention that we are going to have a mediation center in each state in Malaysia, but for PMC19. But other than that, because if I'm not mistaken, since we are dealing with Advocates Association of Sarawak, then they are also they are providing us a group of mediators, in that they might have their own so-called mediation institution of PMC19, yeah, private mediators. I think
Thank you, Mr. With that, I will conclude this session as we have really overrun it. I will pass it on to the Secretariat. Thank you very much, everybody.
Thank you, Ms. Ramit. Thank you, panelists, for sharing the timely updates on the COVID-19 Mediation Centre's effort and recent experience in the functioning of the industrial and community mediation during pandemic, e-mediation, and the HIAC institutional responses on mediation during pandemic. We will now have a very short 15-minute refreshment break before the start of the role-play session by CALCC and ELSA. Do join us back at 4:45 to understand the practical application. My apology, I understand it's only 5 minutes break. So do join us back at 4:45 Malaysian time to understand the practical application of mediation rules. See you then.